a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Here's that real good guy. We got him in, David Whiting, well-known Melbourne solicitor, who I just realised had a business in the city that I've been walking past for, 20 years now and not realising that it was yours.
Okay. Well, the sign's only been up 3, so that's okay.
Maybe that's it. I'm a trained observer.
Yeah,
what can I say?
absolutely.
Good morning, David.
Good morning, Virginia.
Did we have any homework?
We did. We had a gentleman who rang about cost of recovering records from a doctor, the transfer cost, and we had the dentist ring.
Yep.
The answer is it's a remarkably convoluted and complicated billing process contained in the health records regulations. But if it's electronic, it's the organisation's reasonable cost of supplying.
No number put on that?
If it's it depends whether you want to access or whether you want to look or transfer.
Right.
Transfer is reasonable cost of supplying, so you work out what your support staff are paying, getting paid, and then of course if you want it interpreted, there's an extra cost. And the organisation's reasonable cost in assessing and collating the health information not exceeding about $40. So that's where we get the $50 from.
Okay, right.
Yeah.
Does 50 seem reasonable to you?
Well, when you consider what people get paid and the amount of time it takes to verify that the request has come from the right person, verifying who it's gone to, and when you look at what people, if in a sense what actually, you've got to distinguish between the people's wage or salary that they're receiving and the overheads that come with them. So 50 strikes me as reasonable.
Okay. 1300 222 774 if you have a question for David Whiting. Gary is near Ballarat. Go ahead, Gary. Good morning.
Oh, morning. David, I had a storm and the tree fell on a rider mower of ours and contacted insurance and they said to take it to a repair shop, which I did, and they did a written report, took that to the insurance. The insurance then requested photos, went back to get the photos. The mower had been stripped and they were selling parts off it. And I didn't have the heart to send the pictures to the insurance after that, and I was wondering where I go to from here.
Just to clarify, it was just the rider mower, the equipment, not the actual person mower that the tree fell on?
No. Yeah, the
mower
I'm
machine,
not laughing.
The mower person.
Exactly,
yes,
a mower machine, not a mower person. My heart was in my mouth there, Gary.
Yeah.
Right.
Okay, good.
Okay. You have an action for damages against the repairer.
Right.
And I suppose you then got the argument that the repairer made the insurance claim impossible.
Exactly.
So what you need to do is, I would have thought, work with the repairer about what the insurance claim might look like and get a report from them. And then the balance is the responsibility of the repairer. You are entitled to, I suppose your claim is I want back what I had but repaired. Part of the cost of the repair is the responsibility of the insurer, but the repairer has made that impossible. So I'm saying he breached his or her obligation to you, and you have a claim against the repairer for that to the extent you can't get it from the insurer. So go back to the repairer and see what you can get from the repairer and have a go at the insurance company, but point out to the repairer to the extent that you fail, it's the repairer's problem.
Okay.
Yeah.
Good luck, and I hope you actually get some satisfaction there. Shirley in Frankston. Hi, Shirley. What's going on?
Oh, hello, Virginia. Hello, David.
Hi.
Trying to get release of the property that I have owned for 20 years from the bank, the title release. They say I owe them money. They've given me an amount of $434.40. I've given them every detail. I've signed every document. And it would appear that that was when the transfer didn't take place 20 years ago.
Can I give you a different point of view, Shirley? I'm not saying you're wrong, but 20 years ago, people paid out their mortgage and didn't get it discharged. They just paid it out.
I didn't. But I'm sorry, David, to interrupt, but I didn't have a mortgage. I sold a shop, used the money from the shop to buy down here at Frankston.
Yes.
And it was a cheque, a personal cheque. I still have the same account that I wrote that cheque out on that I use today. And they're saying that I owe this money. I've given them I've sold my home. I need the money and I need the deposit of the monies, that all of the monies that are
Sorry,
coming.
is there still a mortgage on your property?
There never has been.
So the conveyancer or solicitor used on the sale would make it clear that there was no mortgage on the property?
Should have done so, yes. And the amount of...
No, does it? Does the title search that your solicitor or conveyancer got show there was no mortgage?
Well, it's an electronic strip which says that I owe the bank money.
No. Can we talk about something slightly different? Your conveyancer will have obtained a register search statement that shows that you are the owner of the property. Does it also show that there is a mortgage on the property?
Well, I haven't seen that, so I don't know. A register search statement. My solicitor has mentioned nothing about that at all.
Right. So what I've recently had is that that the bank, if there was a mortgage, so there might have been a guarantee put in place in relation to your business that resulted in a mortgage being put on your property to support your guarantee. If that's the case, there'll be bank fees of about $320 and a discharge of mortgage fee that goes for the registration of the discharge. And all up, that's about $440.
Yeah, that's $434.40.
Yes.
That is exactly the amount that
well,
was mentioned.
$114.40 of that will be the discharge fee at the Registrar of Titles. So it sounds to me as if there is a mortgage on your property, and it's likely that you will have signed a mortgage. And if you ask your solicitor if there is a mortgage on the title, then that's the process for getting it removed.
But I'm just saying to you that I came down here and paid for this property $63,000 in a private cheque. I still have the same cheque account all these years later.
Well, let me ask you this question then, Shirley. How did the bank get your title?
Well,
because if you had bought the property and paid your $63,000 of the private cheque, the bank would not, in the normal course, be in possession of your title other than perhaps in a security envelope that you left with them 20 years ago.
But you see, that's what I'm just saying to you. I actually have the parchment piece of paper that says I own the property title. The piece of parchment, the original title parchment.
Then just ignore the bank, because what you're telling me is there's no mortgage on your property.
There is none.
Right, so you might, I'm not saying you don't owe the money, I don't know that, but what you're telling me is there is no mortgage on your title. Go back to your solicitor and get them to confirm whether there is or is not a registered mortgage on the title, because every now and then, Virginia, a client will come in and say, I paid the mortgage off 20 years ago, here's the title, and they don't give me the discharge of mortgage that the bank gave them 20 years ago.
Right, which is actually...
And then you need to start again.
Ties the whole thing up. All right, well, there's still a question for your conveyancer or lawyer back in the day, or whoever's working with you now, Shirley. Sorry to leave it as a bit of a mystery, but if you'd like to come back to us and let us know how it ended once you've actually asked that question, that would clarify things. Thank you. Good luck. John in Mooroolbark. Good morning, John.
Hi, can you hear me?
Yeah, yes. Go ahead.
Yeah, thank you for taking my call, Virginia and David. My mum did a will with a solicitor, and they agreed to a fee of 3.5% as an executor. Obviously, she passed away, and then the solicitor started working on it. After a month, he wrote to all the beneficiaries saying that in order to avoid potential conflict of interest, he appointed another solicitor to act on his behalf for the probate.
Yes.
And now what we found is he's charging the fee from the other solicitors to the estate. Shouldn't it come out of his fees that agree between him and my mum?
Depends on what the will says, John. And I'm not defending the position the solicitor's taken, but perhaps explain it. There have been a number of court cases that talk about what's the difference between the work done by an executor and the work done by the solicitor for the estate. And the courts are concerned that unless there's some clarity as what's covered or not covered, it's convenient from the lawyer's point of view to say, well, from the executor's point of view, saying, well, that's the work I'm doing as executor, because to ensure that there is no overlap, then I'm going to get someone else to do the legal work. But my initial reaction is 3.5% of the estate is a higher than usual percentage.
Is it right?
Yes.
Does this also imply that the lawyer is a beneficiary of the will in terms of the conflict?
No. Let's say somebody appoints me to be the executor of the estate. Now, I now do some legal work in relation to the administration of the estate. Does that come out of my executor's commission, or is it I'm paid to do a job, which is to be the executor? There's some legal work. How do I make sure that the client, that is the estate, doesn't end up paying twice?
So, John, what issue are you left with now? Any questions remaining?
Well, that's the main issue. I know that there are other charges that he has charged against the estate, which I thought, well, reasonable.
Yes.
But I thought it was a bit unfair that that it was agreed that he would do the job for 3.5%, and then turn around and charge an extra for work that's done by someone else.
I really do understand your problem, and he's not charging extra, someone else is charging. Your real question is, the real issue is that you don't know what the deal was with your mum, and that's the bit that you can't work out because she's not with us anymore.
So what does John do now?
Well, have a look and see. If I give my executor 3.5% of the value of my estate for acting as my executor, doesn't of itself mean that out-of-pocket expenses such as legal fees in connection with the administration are paid out of that. Logically, it wouldn't.
Okay. Thanks for calling in. Colin in Eltham, good morning. How can we help?
Good morning, Virginia, and good morning, David. I hope you can help me. I've been operating a mobile coffee business with a number of trailers from my home for over 20 years.
Yes.
I've got about 5 trailers and 2 vehicles. The council now tell me that I am only allowed to have 1 vehicle and 1 trailer parked at my property. The vehicle's meant to be under 2 tonne. So what I'm wondering is, does the existing use rule apply here?
Okay. Can I suggest, this is showing off at the moment, Virginia, clause 63.01 of the Nullarbor Planning Scheme?
Go for it, David.
Yes.
Yeah. Have a look and see what it says. The question is, under that particular provision, if you have been using it for an existing purpose for 15 years.
Yes.
Right. Now, it may be that they consider 1 truck and 1 trailer to be a home business. So you need to look at what's not allowed under the planning scheme. And I'm quite sure that when you started this business at these premises 20 years ago, you didn't have 5 trailers and 2 trucks.
Yes, that's right.
So you have to have a look at the planning scheme, see what your as-of-use rights are, have a look and see precisely the extent to which you're breaching and the period for which you are breaching.
It's very hard to find out when these laws and everything applied. They come up in the council, but you can't find out when they are applicable from.
What I want you to do is look at planningschemes.vic.gov.au.
Rightio, okay.
Download the whole of the planning scheme, that is the ordinance, and it will. Your planning scheme will have come into effect in about February 2000.
Are all these vans, are they all on your property or are they on the street?
No, they're all on my property. I'm on a 2-acre block.
Right.
And the council came out to investigate something else, noticed the trailers there and basically started to make claims against me, removing them and finding me and everything else.
The planning scheme will allow for home businesses as an authorised use. The real question is that does the 5 trailers and 2 trucks operating from the premises constitute a home business or constitute more? So it's you go. I would be suggesting that you talk to a planner to work out whether you are within the planning scheme or not now.
Okay.
Right. A planner at the council or a legal planner?
No, they're currently the enemy. All right.
Yes, well.
You're right.
So, Colin, I would be talking to a town planner and ask whether you're compliant or not compliant and when the rules applied from.
Good luck, Colin.
Really appreciate it. Thank you.
That's okay. Thanks so much. Nice that you can help out here. Peter in Reservoir. Hi, Peter. What's going on?
Yeah, hi. My niece signed a contract to purchase an almost completed unit in July last year, with advice that a certificate of occupancy would be issued in August the following month.
Mm-hmm.
Since then, no work has occurred and the site is abandoned. The contract includes a special condition that the purchaser shall not be entitled for compensation or able to rescind the contract as a result of non-compliance with the Domestic Building Contracts Act. The 32-section document includes a copy of a lapsed building permit, noting that the board pier and frame inspections have not been carried out.
We might get to your question, I think.
Yeah.
I'm nearly there. I've got one sentence to go, then I'll get to the question.
We can hear that you're reading. You're doing a good job, Peter.
Yeah.
I have since found out that the vendor, who is also the builder, his licence was cancelled in 2018 for non-compliance on other projects. My question is, given these contract items, can the conveyancer be pursued for professional negligence in not flagging their consequences?
No, not on what you've told me, no. Have we brought the contract to an end yet?
No, the conveyancer has recommended a solicitor who we went to, and the solicitor has said that doesn't think there's any chance of rescinding the contract because of that clause.
Yes, but it's not forever. I mean, if it was a lot on an unregistered plan of subdivision, the base period for plan approval is 18 months. What you ought to... And so there's been no building work because you've got no builder. You're never going to get a certificate of occupancy because the work's not been done unless someone is prepared to come on and take it on. What I would probably making an application probably to the county court to get relief from your obligations under the contract. But your claim at that stage will be against the vendor, not against the conveyancer. Because when we got back to July last year, what was the expectation? Did we know at that stage? Did anybody know that the builder was no longer a registered builder?
Well, they say they don't. The building was 95% completed, and the agent said that it would be finished within the month, and the certificate would be issued. The agent is saying that they have no knowledge that the builder was deregistered.
I think that's probably right, because they will have relied upon what the builder told them. What you need to do is work out whether you want to enforce the contract or get out of it.
That's two ways of going.
Well, you might say, I want an action for damages because there's an assumption that we will resume work and carry on. I would be inclined, but the difficulty is that you might get a builder who'll complete the 5% of work, but what are we going to do about the 95%? Because you won't have a builder's guarantee for it.
That's
or
right.
Unlikely to.
Yeah.
And the building permit will need to be renewed because it's stale. So it's a monster. Fixable, but if I was
Requires
Peter, I'd be
legal
looking
help,
at
this
how
one.
do I fix the problem?
Yeah,
Yep.
okay. Good luck, Peter. Hope that's helpful. Roger in Strathmore. Hi, Roger. What's going on?
Hi, Virginia and David. We own a apartment which has been subject to some water damage from a light shaft, which is Body Corporate responsible. We found out since that it has no membrane under it. There's been quite extensive damage to the carpet, which the Body Corporate came in and cut a hole in the wall to find out where the leakage is. We're in the process now of fixing it.
Yep.
We've had to get the carpet redone or relaid throughout the house, throughout the apartment actually, and we've actually got the whole place repainted because the painting job originally was 15 years old. We're trying to recuperate, we get back the money from the Body Corporate. They're claiming, we had no landlord insurance at the time, so they're claiming that they're not covered under their insurance for the carpet. They're looking at...
They wouldn't be because it wouldn't be covered by their insurance, but if you've got a claim against the Owners Corporation for failing to maintain common property, that would be covered under the negligence provision rather than the asset provision, if you like.
Okay.
So you think about a water tap, you've taken out land, let's say you've got landlord's insurance and the tenant allows the tap to run and you get water damage, that's covered by the policy, right? But if the water's come in from externally because someone else has failed to maintain what they should have maintained, you then have a negligence action against the Owners Corporation.
So next steps would be, do you think?
I think it would be ask the Owners Corporation for a copy of their policy
And then...
and see whether it's covered or not covered. And you've got to see Roger, what did the owners' corporation do wrong, as it were?
Mm-hmm.
Because if the owners' corporation was created upon registration of the plan, it would not be within the knowledge of the owners' corporation that the membrane you talk about at the bottom of the air and light well would have known. They wouldn't have known it was or wasn't there. What should they have done?
Okay, we might leave it there, Roger. I hope that's helpful.
Yes, thank you.
Thanks so much. Kylie in Ballarat. Kylie, good morning. What's going on?
Yes, good morning. David, my husband sold an old car through his car club, and the purchaser picked the car up, signed the contracts, paid in full, and was in the process of driving the car home to Sydney, and decided he'd made a mistake.
Is your husband a registered car, LMCT, a motor car trader?
No, private sale.
Firm contract at the time the document was signed and the money was paid?
Yes.
You don't have to give the money back.
Right. So if he's on his way back, he got halfway back to Sydney and he's on his way back.
Yes.
Are we obliged to give him the money back and take the car back?
No. Not on what you've told me. The Fair Trading Act and the Australian Consumer Law don't apply because you're not a trader. So the trader provisions don't apply.
Right.
There's no cooling off period, which you'd get if you bought from a motor car trader. So it's a firm sale when they shook hands, signed the document and parted with the money. Is
the purchaser alleging something wrong with the car that you didn't disclose? No?
No, nothing mechanical
Just
at all.
Changed their mind.
Changed their mind, decided it was a little bit awkward for him to drive. It's an old, an older style car.
Yep.
Yes.
And decided it was a bit awkward. And
no cooling off provision, no consumer law issues, no allegation at this stage that the car wasn't as described?
No.
No, you don't have to. It doesn't make your husband... I mean, I presume you would be quite happy to get rid of the car and your husband might quite like it back, Kylie?
No, he's actually happy to get rid of it this time.
And Kylie, the purchaser is on their way back to you now?
Yes.
Oh, that's going to be an awkward conversation.
Yes.
It is, isn't it? Go away for the weekend.
What are you going to do, Kylie?
Well, I'm not... Well, my husband is willing to give the money back because just for goodwill.
Right.
Yep.
It's it's a person he knows, but perhaps would it be suitable if he kept the deposit because the man initially paid a deposit.
Kylie, it's your call. I would be coming along and saying, I've got to go and sell it again. I've got to look at after again till I've sold it.
Yeah.
So you might come along and say, look, I'm not going to give you all of the money back, but I'm going to retain X dollars, recognising I have to re-advertise, I have to do all sorts of things, and people are going to ask, why didn't the sale continue? Because if he sold through the car club, other people in the car club will know that buyer changed his or her mind, and that's going to affect the price that your client got. Or you might say, I'm happy to put it on the market for sale again, and when it's sold, I'll add up my extra costs and I'll give you back some money to the extent that at the end of the day I just want to be square on the deal.
Yes.
Does that sound reasonable?
Yes, that does. Thank you very much.
Do you think it has to be a testy exchange or could this be done politely?
My husband's just left me a voicemail as I've been talking to you, so I expect...
I'm very pleased that he's an ABC listener, Kylie.
Well, he's at work. Yeah. And I might be left at home to deal with it, so I'm not sure how it's going to go.
Oh, dear. Good luck. That sounds like a complex situation, but a nice solution there, David. We'll see you next week.
See ya.
David Whiting there helping you out as ever with your legal challenges.